Hello, everyone, and welcome to our second Excellence in Legal Research summer session. Today we're going to be talking about legal research analysis. So analysis is going to be an important piece of multiple steps within our research process. So we'll talk about what it means to conduct a preliminary analysis, which is really the first piece of our four-step process that we're going to be working through in seeking to find a solution or answer to a legal research problem. But then analysis is also going to be important when we're trying to determine how sources fit together in order to answer a research question. So that's to say that it's also important a little bit further down the line once we've gathered sources and we're going through the process of analyzing how they apply to our research problem in order to help us find an answer. So in order to get us thinking about legal research analysis, I want to first have you take a moment just to either think to yourself or take out a blank piece of paper, open a Word document. Take just a few minutes to think about, why do we perform legal research, right? What is the goal when we're performing legal research? Hopefully you have identified that ultimately we're looking for primary mandatory authority that we can use to answer the legal research question at issue. And that can be cited in a legal document. So as a refresher, what do we mean when we say primary? Primary is the law itself, right? It's either a statute or regulation. It could be case law. It's the actual law as opposed to a secondary authority which helps us to interpret the law or primary authorities, right? And we're looking for a mandatory authority as well. So what does that mean? So we're looking for authority that is within our jurisdiction and speaks precisely to the legal issue that we're looking at. Is that always going to be possible? Not necessarily, but that's the goal, right? The goal is to seek out primary and mandatory authority that can answer our question and be cited in a legal document. And if mandatory authority is not available, then we look to collect other authority that may be convincing, right? We'll usually cite to primary authority in legal documents like a memo or brief. You're likely familiar with this, having gone through at least a semester of law school and gone through the memo writing process. And so in thinking about how we go about this, right, let's think back to the research process. And we're going to reflect back on our four-step research process, which will hopefully lead us to relevant sources that are going to help us to answer the question, right? That's the goal. We're going to use the four-step research process in order to seek out primary mandatory authority that can answer our question. Let's review the steps in the research process. So hopefully you'll recall that here at Texas Tech, we focus on a four-step research process. And the first step within that process is called our preliminary analysis, right? So this is where we are seeking to identify the legal issue or perhaps multiple issues that are at play, and we're seeking to hone in on the research question or perhaps multiple questions that are at issue, or potentially there are subparts to the research question. But here's where we want to think through what our question is and kind of evaluate the fact pattern in front of us, looking at all different types of factors that will help us to determine how we can best find an answer to our question. The preliminary analysis is that critical first step, so we're going to focus significantly on that today, because if you skip this important step, who knows where you'll wind up. So you want to work through this preliminary analysis piece of the process. And we'll talk a little bit later about, what sort of things what we should be thinking through when we work through that preliminary analysis. So step 2 of our 4-step research process is looking to secondary sources. So why would we consult secondary sources? Hopefully you're thinking that we would want to review secondary sources in order to help us better understand our legal issue. It could very well be a legal issue with which we're not familiar. And it could be, a legal issue where there's keywords and phrases that we're not necessarily familiar with. We need to gain some background understanding of those terms and phrases. Consulting secondary sources will help us to do this, and it'll also point us to our relevant primary sources, right? So that's one of the big benefits of using secondary sources, is that they point us to relevant statutes, regulations, case law, all different types of primary sources that are relevant to our legal issue. So that's how we get to step 3, right? Step 3 is where we move on to codified law, or our primary sources of law. So if our legal issue is governed by statutory law, the first primary source we consult will be a federal or state statutory code. Hopefully we've gone through some secondary sources that have pointed us directly to that relevant code. If we're looking at an administrative legal issue, we'll want to consult regulations, right? And then from step 3, moving from codified law into step 4, we're still looking at primary law here, right? This is still the law itself. These are not secondary sources that are interpreting the law, but this is not codified law. This is not something you're going to find in a code, right? This is case law. So this is law that has been interpreted by the courts, and this is the step that we move into in the instance where there's not a relevant statute on point, right? There's not a relevant regulation on point, and so we are looking to how the courts have interpreted case law to help us answer our legal question. So again, just as a review, our 4-step research process, we start with our preliminary analysis, and that's where a huge piece of this legal research analysis is coming into play. Then we move on to consulting secondary sources. Working through that first preliminary analysis is going to help us be able to identify the proper secondary sources, right? Because we've worked through what we're looking at, what we need to find, what words and phrases may be relevant to help us find the right secondary sources. Then from those secondary sources, we're moving on to seek out codified law, and the secondary sources may be pointing us directly there. And then from that step 3, where we're seeking out codified law, we'll move on to seeking out case law precedent. It may be mandatory case law precedent, it may be persuasive case law precedent. So again, what does that mean? If it's mandatory, it is specific to our legal issue, it's within our jurisdiction. If it's persuasive, it's not necessarily binding, right? It may be relevant, but not within our jurisdiction, but it might be something we still want to include for the court to consider, or for the reader of our legal document to consider, right? So that's our 4-step research process, and as we move throughout all of our sessions in the Excellence in Legal Research course, we're going to continue to pull back to this 4-step research process and dig into each of these respective steps. So again, hopefully one of the key takeaways here is that the preliminary analysis step is a critical first step. That's we're kind of going through this legal analysis as a puzzle, right? So each statute or regulation or case that we find is the puzzle piece, and we need some context and an idea of the bigger picture in order to determine how these primary sources fit together. So the preliminary analysis prepares us for the next steps within our research process, and it provides us with that bigger picture. It provides us with a goal to which we're working toward. And when we have that big picture, we can better understand how all of these pieces, whether cases, statutes, regulations, local ordinances, whatever it is, how will they fit together in order to answer our research question. So you want to think thoroughly through your issue before you begin to research. You want to understand what the issue is, you want to frame your issue, you want to frame your research question or questions. And we also want to remember that there's no such thing as a perfect case, right? You're not looking for one perfect case that exactly matches the set of facts that from your research problem. Not likely that you'll find that perfect case, right? But you can find relevant cases that are applicable, that are mandatory, right, within your jurisdiction and relevant to your legal issue that can be included. And if there's more than one, then you want to try to bolster your argument to the extent that you can and include as many of those relevant cases that help to answer your question, right? So we're looking for multiple relevant primary sources that we can analyze and apply to our facts in order to answer our research question. What sort of things do we want to be thinking about as we're working through our step 1, our preliminary analysis, before we start conducting our research, right? We want to plan our research, and to do that, we think through a number of different issues. So, of course, we want to think about what is relevant in the fact scenario before us, right? We want to understand what facts are significant for our legal question and what facts are not significant to our legal question. We want to identify those key facts and determine which facts are actually legally significant. We want to start thinking about and brainstorming key terms and phrases, right? We want to start thinking about the terms and phrases that we will use within research databases. We don't just want to jump into the database and start typing a bunch of different things, right? We want to look at the information in front of us, determine what terms and phrases may be relevant and might help us to find an appropriate answer. Now, sometimes we may do a great job of identifying key terms and phrases that are relevant from within our preliminary analysis, and sometimes it's going to take getting to step 2, getting into secondary sources in order for us to recognize that, hey, maybe this term or this phrase isn't necessarily the most relevant term or phrase that I could be using in order to find an appropriate answer to my question, right? That's oftentimes going to be the case when you're looking at a new area of law with which you're unfamiliar. But it's still helpful to work through that piece of thinking through key terms and phrases before you move on to secondary sources, right? So it may be the case that you are able to identify key terms and phrases that are going to be super helpful. It may not, but regardless, it is helpful to work through that process and to start putting some of these things on paper before you jump into databases. From there, we want to identify the legal issue at play, right? We want to figure out what is our legal issue that we're looking at, or perhaps there are multiple legal issues. Perhaps there are subparts to the legal issue in front of us. So we want to identify our legal issue or legal issues using our significant facts, right? Because we ultimately want to find primary mandatory authority, we will want to note jurisdiction, right? If we're looking for mandatory authority, meaning authority that is applicable to our jurisdiction, we want to absolutely know what jurisdiction we're working within, or perhaps we're working within multiple. but we want to certainly be aware of that, and we can identify that through the process of working through a preliminary analysis. Lastly, we want to conduct really what I call a knowledge assessment. So we want to start thinking about our own knowledge of the legal topic, right? New attorneys are not experts. During the first few years of practice, you will need to consult secondary sources to learn more about the law. If you're a new attorney in a new area of law, you may want to begin your research with a treatise specific to that area of law. But you want to better understand your legal issue and be able to identify legally relevant facts. And in order to do that, you sort of have to step back and take stock of, what do I know about this area of law? And what do I need to know about this area of law in order to answer this research question? So these are a number of things that you'll be thinking about as you conduct a preliminary analysis. The final product of a preliminary analysis is the research plan. I have uploaded a folder with a number of documents that will be helpful for your research, analysis, and planning. Not everyone is the same. Not every law student is the same. Not every attorney is the same. People have different ways of working through this analysis and through the planning process. So I would encourage you to explore those documents and kind of think about what works for you, right? You'll see included there is a template, a log, a checklist, and a worksheet to choose from. There's plenty of other resources as well. You can look online and find research planning documents in addition to those that I've uploaded within the folder. But I encourage you to look through all of those because I want you to choose at least one of those to use for your final assessment. And when you're looking through those, I also want you to start to think about, whether what you've chosen might change based on what sort of problem you're dealing with. If it's an area of law that's new to you, might you want to choose a planning document that's a little bit more extensive? Whereas, if you're more familiar with a certain area of law, maybe you feel more comfortable using the shorter checklist. And your use of these planning documents will evolve over time, right? You will likely not need to use these planning documents as a highly experienced attorney if you're dealing with a legal issue that you've dealt with many times before. So take a look at each of those documents, kind of think about which of those documents might be helpful to you, because I want you to use at least one of them in your as you complete your final assessment. And you can certainly explore multiple. I think that's great. I definitely encourage you to do that. But just note that there are a number of different resources that can be used to help you through this piece of the preliminary analysis that is, the research planning piece. There are a number of different methods that you can use to help you identify relevant facts and issues, right? So one method to sort of get you thinking and help you identify those relevant facts is, a tip that you may have learned in grade school called the 5 W's, where you're thinking through who, what, when, where, and why, right? So the 5 W's, we're looking at our fact pattern, we're asking who, what, when, where, and why. When we're thinking about who, we are thinking about the roles of the parties, right? Not the names of the individuals involved. We're looking at the roles of the parties. When we're thinking about what, we're thinking about, again, what facts are legally relevant, what facts are not. When, maybe when the events occurred. but it might not be one particular time. It could be for a period of time, or when a condition was discovered, or when an arrest or a search took place after information was received. So we want to think through all of that as well. The question of where may go to jurisdiction, as in what state or town was the location of the legally relevant events, but it may also be whether an event took place in a home or a business or a public school or a private school. Anything relevant about the location or locations of events would fall into this category. The why is probably the most critical question of all the 5 W's. This is where you want to state the research question based on the facts and what you've been asked to do. So this will dictate the direction of the rest of your research plan, right? You want to ask yourself, why has this issue been brought to me? Why does the client need help? What are the specific legally significant circumstances surrounding this question? Sometimes this may be super obvious. Sometimes it may be less obvious. But just one tip to kind of think through the 5 W's: who, what, when, where, and why, as you work through that preliminary analysis. Those are really helpful things to think through. After we have worked through the 5 W's in order to identify our legally significant facts, we can use those facts as a starting point for search terms, right? So here's where we want to start thinking about key terms and phrases. And we want to brainstorm search terms that we can plug into the databases. We can start using relevant facts from our fact pattern. We want to include synonyms so we don't miss primary sources that address our legal issue but are housed under a synonym instead of the word used within our fact pattern. So, for example, let's say that our fact pattern uses the word car. We want to expand our search terms to include automobile or motor vehicle. So we want to be thinking through that. We want to be thinking about other synonyms that could be housing information related to our question, and jotting those down, right? As we're working through the preliminary analysis, we want to be thinking about each and every direction that we can go that may house relevant information. And this is just, again, to ensure that we are not missing relevant resources, that in this instance, for example, are using the word automobile or motor vehicle instead of the word car. Let's use the preliminary analysis techniques we've talked about to break down a research problem. So we're going to think about Abby's case. So let's envision Abby, who is your firm's client. She recently went to Chicago, Illinois to visit her parents. While waiting for them in the lobby of their apartment building, she decided to use the restroom. The building's lobby restrooms are unlocked and accessible to the public. When she entered the restroom, she was surprised by a man who tackled her and grabbed her purse. And in the process, she fell and broke her arm. The thief was never caught. I'm going to ask you to take just a minute and write down the 5 W's. So remember, we're thinking through who, what, when, where, and why. Okay, so let's work through those. Who, right? Who are the people at issue? We've got a doorman in this scenario. We've got a landlord and tenant. What's happening, right? She's tackled. Her purse is stolen. When is this happening? Daytime, right? Where? This is in a public restroom. It's in Chicago, Illinois. But why? Why is she here, right? What is Abby asking us for? So that information isn't provided to us. So we need to do some additional interviewing to find out why she's contacted us, right? She wants to see the security company hired by the apartment building. But what's the why? You don't know because you haven't yet been given a question to answer. This is just a sequence of events. You're missing a key piece of information regarding why she's come to the firm. So it turns out that Abby wants to know if the management company hired by the building to provide security and doorman services is liable for injuries on account of being negligent, both in failing to keep an unauthorized man from entering the women's restroom. So this means our why statement might be something like, we want to put it in question form, so we might say something like, in Illinois, is the company who provides security services liable for injuries caused by unauthorized individuals who are able to enter the premises due to the negligence of their employees. Let's look at that in writing. In Illinois, is a company who provides security services liable for injuries caused by unauthorized individuals who enter the premises due to the negligence of their employees. So now we've taken our issue and clarified our issue. We put it in the form of a question. And so now we can move on to the next step of thinking about search terms or queries that might be helpful as we conduct our research and build our queries. So now we are thinking through some search terms that we might use, right? We've pulled some keywords that are relevant from the fact pattern that was given to us, like doorman, what's happening here, she's been tackled, and her purse has been stolen. So we might start thinking about some synonyms, right? So instead of doorman, maybe we might find a case that uses the language guard or concierge or security. Instead of the verb tackle, we might find some information using the words push, shove, assault. Rather than purse, we might find bag or backpack or wallet, right? Some helpful tips in terms of thinking about how to brainstorm search terms or phrases. You might use an index, right? An index is compiled by a human, and so these terms are meaningfully arranged so that the researcher won't miss them. Codes have an index, so that can certainly be helpful to you. When researching cases, you can use a digest as an index. And then also, if we're doing a keyword search in Lexis or Westlaw, one thing that we can use to include synonyms to expand our search is just the, I don't know exactly what the tool is actually called, but there's a tool where you can go in and add synonyms both on Westlaw and Lexis. And so this would pull in search terms that we might not necessarily think of on our own, and this is a newer tool that's available on Lexis and Westlaw. So I would encourage you to keep that in mind as a potential resource as well. Here is an example of what that would look like on Westlaw. As you can see, if you're using the advanced search option, you can use the thesaurus. It will pop up, like I've used the word guard here, and then you can see the thesaurus pops up, and I can click into that, and then it'll show me synonyms for the word guard. So It's your job to go through here and determine which of those synonyms would be relevant for your query. Some may be relevant, some may be not relevant to your question at all. Of course, words can have multiple meanings, and so not all of the synonyms that are suggested by these platforms are going to be relevant for you. But this is just a tip to keep in mind, something that has not always been available on these platforms that might be helpful to you in seeking to expand your searches. As we said, we also want to identify what knowledge we have and what knowledge gaps we have, right? So this is where you're thinking about what you know about this particular area of law and what you need to know in order to answer the question, right? So if it's an area with which you're unfamiliar, you may want to fill in your knowledge gaps with a secondary source. So with this particular case with Abby, the jurisdiction is Illinois, so we might start with Illinois jurisprudence as a secondary source. We might look for an Illinois treatise on property, since this is a property issue. So then we'd go deeper into a chapter on the landlord-tenant relationship, right? But if it is an area of law with which you don't have strong familiarity or a whole breadth of knowledge, you want to make sure to identify those knowledge gaps and then seek to fill them in using a secondary source. And these are just a couple of examples. Now that we have a research plan, we can actually move on to searching, right? So when we're ready to search, we can use Boolean operators to expand the search, and we can use the search terms that we identified in our preliminary analysis, as well as, the synonyms that we looked at previously. But it is only after we've worked through our preliminary analysis and worked through creating a research plan that we can start to dig into searching and building queries and seeking out relevant information. We have to go through that first step of conducting our preliminary analysis before we start digging in. Now, again, I don't really care, what sort of resources you use for your analysis and planning. Once you get into that folder with the various resources, you might, prefer a template. You might prefer using the log as a newer researcher and jotting down, everything it is that you're looking at. And then as you become more familiar as a legal researcher, you might feel more comfortable using a checklist. And then once you're super familiar with an area, you might not need that anymore. So it's a process, right? But as beginning legal researchers, we want to make sure to document what we're doing. So again, I'm going to encourage you to explore all different types of documentation that can be used to help you plan your research. Find what works best for you, and then again, think about, whether that might change based on the sort of research problem you're looking at, or how it might evolve over time as you become more accustomed to conducting legal research. So for the final assessment, you can use any of the resources that are available: template, log, checklist, worksheet. I just want you to use something to assist you as you work through the process. And then make sure to submit your final assessment by midnight on June 19th. If you have questions, please feel free to reach out to me. I will list my email on the next slide, and I'm happy to take questions if you have any further questions about
your preliminary analysis or research planning. I look forward to hearing from you and to reading through your final assessments. Thanks so much.